I'm a combat sports fan and an attorney who specializes in administrative law, which includes many combat sports matters that might be handled through arbitration or before the commissions. Uh, I handle business law issues, an area in which I also consult outside of the parameters of the attorney-client relationship, and civil litigation, where I'm currently engaged in some high-profile cases against some very known parties and entities. Um, I started this channel and this sort of little enterprise here because, first of all, I'm a huge fan of combat sports, as I've already stated. As an attorney, naturally, I'm interested in the legal events that impact, combat sports athletes. And I notice that there are people out there trying to discuss these matters and trying to gain a grasp of what's going on in this field. But I saw an opportunity for someone like me who can step up and provide more accurate and more insightful legal analysis. I have no issue at all with anyone borrowing my analysis of these issues as long as it's not taken out of context or anything. But I certainly don't have any problem with anyone using this, from a fair use perspective or what have you, just to provide insight. So that being said, let's get it in. This video, I'm going to be discussing the case between Terence Crawford and Top Rank Incorporated. Just want to start off by talking about the different parties very briefly. If you're listening to this video, I'm pretty sure you know who Terence Crawford is. He's a 3-division world champion. He's a pound-for-pound great. He's either listed at pound-for-pound number 1 or pound-for-pound number 2. Currently, he's the former undisputed champion at light welterweight, which is 135. That's a distinction that is pretty prominent. If I recall correctly, he would be the third athlete in the modern era to reach at that, to actually make that accomplishment, either the third or the fourth, but I'm pretty sure it's the third. It would be Bernard Hopkins, the gentleman who beat Bernard Hopkins, and then it's Crawford, or it's Katsazu. Okay. Anyway, he's either the third or the fourth to hold that distinction. Now he moved up to welterweight, and he's held the WBO belt since 2018. If you follow boxing, you know that he's been pursuing high-profile opponents. He recently secured a bout against Sean Porter that ended up being Sean Porter's retirement match, but he stopped Sean Porter in that fight in the 10th round, and everyone knows that he's been pursuing Spence for quite some time. There's issues and questions and debates over who's ducking who. But this lawsuit between Crawford and Top Rank, I think it provides some insight into that entire sort of ordeal and what was really happening there. But anyway, I just want to clarify lastly that from a business and legal perspective, it was Top Rank's job to promote Crawford. His inability to secure high-profile fights would not be the fault of Terence Crawford. It would be the fault of who his promoter is. A lot of high-performing athletes and individuals in general find it necessary to focus on their craft. That's the secret to success a lot of times, is to focus on your craft, not to get distracted trying to do things and trying to do jobs that can be delegated to others. So from that perspective, that's who Terence Crawford is, and I don't think I think he's great at what he's done, at what he does. He's arguably my favorite boxer. But I'm going to be objective, notwithstanding. Now, Top Rank is a privately held corporation. It's a boxing promotion company founded by Jabir Muhammad and Bob Arum. Now, interestingly enough, a lot of people don't know that. A lot of people don't know that Top Rank was actually founded by a black man in conjunction with Bob Arum. Jabir Muhammad, he's from Detroit, Michigan, my home city and state, and he is none other than the son of Nation of Islam founder Elijah Muhammad. Jabir Muhammad was previously the manager for Muhammad Ali, and Top Rank, it's a powerhouse in the boxing promotion world. So many high profile and famous athletes, boxers have been represented and promoted by Top Rank. I mean, Ali, De La Hoya, Duran, Frazier, Foreman, Hagler, Marquez, Pacquiao, the great Floyd Mayweather, Sugar Ray Leonard. List goes on and on. Sort of as an aside, uh, you could argue that Top Rank may have started. I'll put it this way: a company called Main Bout, and it could be considered the first sort of launch for Top Rank or of Top Rank. And this company, Main Bout, was actually founded by Muhammad Ali just to sort of handle his promotions, etc. And Jabir Muhammad was his manager, but then you had other owners who participated, including Bob Arum. So interesting founding, and I think that the fact that there were, not just Jabir Muhammad, but actually other Nation of Islam members were early investors and early equity owners. It may play into Bob Abrams and Top Rank's ability to defend against this suit, at least at a bare minimum in terms of public perception. But there's more to be said about that down the line. Anyway, those are who the parties are. So Crawford was represented by Top Rank, and he's making some allegations in this case that are going to be pretty interesting, and we're just going to kind of look at that and see what we can conclude. Now, what Crawford is actually suing Top Rank for, in legal law, in lawsuits, you have claims or causes of action. So in Crawford's suit, there's about six causes of action, and a lot of times lawsuits are amended, so we'll see changes taking place over time. But we have a breach of contract cause of action that's related to his promotional rights agreement, and we'll get into that. We have another breach of action, cause of action that's related to the Kavalauskas or the Mean Machine bout agreement from 2019. And there's a fraudulent misrepresentation claim here, a negligent misrepresentation claim, a breach of implied covenant of good faith and fair dealing, and finally a tortious breach of the implied covenant of good faith and fair dealing. So I'm just going to briefly discuss that and give you kind of a layman's perspective. I'm going to give you a perspective in layman's terms, rather, as much as possible, of what those claims represent and what's going on. Before I go any further, I'd like to say that there were some changes to the lawsuit, to my knowledge. I've actually requested more information on this lawsuit because, from what I understand, the form that this lawsuit was presented in, to me it looks kind of like a lawsuit for federal court. So I know that some changes were made, but this is the only version that I've been able to get a hold of so far. When the lawsuit is amended, if there are any meaningful or material changes, I'll be happy to discuss it. So there's an introduction portion here, and some shots are definitely fired. Okay, but I'm not going to actually spend a lot of time on the introduction phase because I'll tell you that the introduction is really to help you shape this lawsuit, to get an idea as to where this person is coming from. I really don't want to spend a lot of time on the actual introduction. That's something that you can sort of read yourself here. But I want to get into the claims, and then maybe we can go back to the introduction to the extent we think it's necessary. Just in terms of helping us kind of gain a grasp of what's going on, though, maybe I'll start with just reading just the first paragraph. For years, professional boxers and others in the sports world have called out Top Rank's owner Bob Arum for his disparate treatment of black boxers, including those very same black boxers that Top Rank is contractually obligated to promote. Because this is boxing, a sport with a checkered history, and because Arum is now dismissed as just a grumpy old white man, Arum continues to make racist and bigoted statements and purposefully damage the reputations of black boxers without any consequences. That's a pretty bold opening. You know, I mean, from what I understand, the firm handling this has had a lot of success, with high-profile cases. I'm not entirely a fan of that opening. The dismissed as a grumpy old white man. It just, it, it's a kind of statement that you would maybe make if you want to catch attention, but goofy is a strong word, right? But it sounds a little goofy to me. I would wonder who would write that. I guess when I start out reading this intro, to me it sounds like a lawsuit that was drafted to make a black person think that they're being advocated for, zealously. Now that sounds so bad. I don't mean it in a negative way, but that's really what it sounds like. It sounds like someone's trying to, oh yeah, let me convince this client I'm going hard. But we're gonna go move on beyond this and kind of see where we're going. This is generally because the affected boxers who are in long-term contracts with Top Rank fear that if they speak up, they will be placed on the sideline and not given the opportunity to fight during the life of their deal, which could be 5 to 7 years. Less than 2 weeks before this complaint was filed, Top Rank through Arum called World Boxing Council interim heavyweight champion Dylan White a black man greedy for requesting what he believes to be a fair dollar amount to fight WBC lineal heavyweight champion and Ring Magazine heavyweight champion Tyson Fury. Okay, so right there, the goal is to kind of paint this picture of Arum as a racist. I'm not suggesting it's true or untrue, just saying that that's the rationale, and they're reaching out to the Dylan White situation, in an effort to kind of help paint that picture. I wouldn't have started with that introduction because to me, that statement about Dylan White being greedy is not a smoking gun. It's not really powerful enough to me to gain the impact that one might hope to gain in a situation like this. But that's my opinion, totally. The champion Tyson Fury, a white man. Ugh. Okay. Meanwhile, Top Rank's president Todd DeBuff, who is fully aware of Arum's racist statements and disparate treatment of black boxers, keeps his mouth shut, waiting to take the helm of Top Rank after Arum dies or retires. Huh? Okay, since Top Rank and DeBuff will not police themselves, do the right thing, and move forward as a responsible business in 2022, Crawford, who backs down to no one, will make them do so. I wouldn't have said that. I wouldn't have said that. Why wouldn't I have said that? Well, because I think that there are some judges where when they hear you speaking so confidently about what you're gonna do, it's human nature. I'm not saying it's an appropriate action to take, from a juridical standpoint or whatever, but I'm just saying that there are people who would look at that and say, well, we'll see about that. No one's going to tell me what to do. So I would be careful about sort of invoking that backlash potentially from a judge. So that's not a statement that I would make, and it's certainly not a statement that I would make on behalf of Crawford, because I personally don't believe that wealthy black men are sympathetic litigants. Now, what I mean by that essentially is that there are people, there are, let's say, demographics of people, financially, racially, otherwise, who are considered, maybe a more sympathetic party, and you might be able to pull at the heartstrings or the conscience, of a decision or a fact finder or decision maker in a case like this. Millionaire young black men don't necessarily fall in that category. So I would kind of I would not put the emphasis on Crawford in this sort of way. Now, the next paragraph, they kind of go on about his accomplishments as a boxer. They say he's also a proud black athlete. It's another line that I absolutely would not include. I would not say, and again, it's because when you're dealing with law or business, so much of this boils down to psychology. So the question is, well, how does a judge feel when the judge reads Crawford is a proud black athlete? I'm not, again, it goes back to not being a sympathetic litigant per se, as a young millionaire black man. Is that the kind of statement that'll help sway a judge in your favor? Absolutely not. I can tell you that. Absolutely not. Certainly not in this context. Perhaps if there were overt claims of race or claims of overt racism, right? Then maybe emphasizing the proud black thing would go over well. I personally don't like that approach. Now, listen, I don't want this video to be too long, so I'm going to move on to the claims. Let's get to the meat and potatoes. Let's look at the first complaint, the first cause of action in the complaint. Okay, so these are like factual allegations, and you lay out facts that are going to be sort of relevant to all or many or most of the claims. In this case, it's all. But when we get to the actual causes of action, it begins here on page 13. Breach of contract, promotional rights agreement. Now, in this cause of action, this is the first one. This has to do with the fact that Crawford claims that according to his agreement, Top Rank was obligated to offer him 2 fights a year. And bottom line is that according to him, they didn't offer him 2 fights between October 2019 and October 2020. There it is right there in paragraph 58. Okay, to prevail on that claim, all Crawford really needs to do is allege and show that, look, he was ready to go. Top Rank didn't deliver. Later on or elsewhere in this complaint, there's claims about what the average compensation was for each fight. I believe it was in the 4.5 million range. So then the argument is by failing to offer that second fight, essentially Top Rank prevented Crawford from being able to earn another 4.5 million on average. And at a minimum, they're going to owe him that 4.5 million. Sounds like a perfectly reasonable claim to me under the circumstances. Second cause of action, and we're going to get into the plausibility and all of that, but for now I just want to run through these real quick. Breach of contract based on this 2019 Kavalauskas bout agreement. In that second claim, Top Rank and Crawford, they arrived at this deal where in order to induce Crawford into accepting this Kavalauskas fight, they told him that, look, we're going to deliver on this Spence fight. It's right around the corner. Just hang tight. They told him, look, we're going to pay you a $900,000 bonus by the end of 2020 if we don't deliver on that fight. Okay, so what do? As we all know, the fight never happened. Not only that, but Crawford never got the $900,000, and actually the bonus was in excess of $900,000. So he never got that bonus as well. Based on my reading of it, and in law in general, you got to look out for technicalities. So they talk about a bonus of over $900,000, and they say that Top Rank failed to deliver. So if they failed to deliver on the bonus of over 900,000, it's not exactly the same as saying that they failed to deliver on a bonus period. But we can look at the amounts that he's pursuing to kind of gain more information on that. However, in general, in lawsuits, at the end of the lawsuits, when you're asking, it's called a prayer for relief. When you're asking for what you're asking for, and we'll see this in this case, you don't necessarily see a specific amount listed, and that's because they generally say it's provable at trial. So they're going to present evidence and kind of come up with the final number at trial. Although 10 million is somewhere, it's listed somewhere in this case. Okay, fraudulent misrepresentation is next. And the fraudulent misrepresentation, I'll tell you, is basically when you lie to someone to get them to do something, right? And they engage in that action relying on what you actually told them to do. And as a result, they incur damages, right? Or they suffer. It negatively impacts them. So fraudulent misrepresentation as applied to this situation, it's a let's see here, yeah, it's this Kavalauskas bout agreement, right? Where essentially Crawford is saying, look, they told me if I take this fight, they'll deliver on Crawford. They failed to deliver on that Crawford fight, you know, and part of the damages that they're going to be mentioning here is certainly going to be the legal fees, you know. Uh, okay, now, here's what's interesting here. So for this fraudulent misrepresentation, it's not a misrepresentation that you make accidentally. Crawford is saying that they intended that. They knew they couldn't deliver on the fight. They failed to deliver, but they lied to him deliberately so that he could accept the fight. Now, I'll tell you right now that Bob Arum and Top Rank, they're going to argue that Crawford wasn't damaged by this reliance. This is almost certainly what they're going to argue, right? And while Crawford's team is going to argue that, well, yeah, the damages are legal fees, uh, I would argue that's not quite what the law is referring to, when they're talking about damages. So in other words, you know, let's say a bus driver, hmm, let's say, I don't know, let's say a navigator plots a certain plots a certain direction for you to take on a trip. You follow that direction, it leads you right over a cliff, car crashes, goes over the cliff, you break two legs. Okay? The kinds of damages that you'd get in this scenario, this is kind of a goofy scenario that I offered, but the kind of damages that you'd get would be damages relating to the suffering that you experienced and the hurt that you experienced as a result of following those instructions. Well, Crawford won the Kavalauskas fight. He was paid for the Kavalauskas fight. So there is a lack of damages in that sense. The fact that Crawford decided to sue Top Rank over this matter, you could argue it wasn't necessarily justified, so therefore those damages don't really count. Or you could argue that, okay, well, we'll pay for his legal fees. And depending on how early they settle, we could be talking about a number that's not significant at all. We could, it's a, 10, 20, $30,000. It could be as low as that, really. So let's see here. Let's see if he's alleging any other damages. Now they're saying Top Rank is guilty of oppression. I don't. I'll leave that alone. Fraudulent misrepresentation of malice by purposefully making false representations to Crawford is set forth herein. Crawford is therefore entitled to punitive damages in an amount appropriate to punish and make an example of Top Rank to the community. Okay, well they deal with that here. So they know that they're not really looking at real damages. So what they're arguing is that the court should punish Top Rank because of the fraudulent misrepresentation, not necessarily that Crawford sustained any real damages. Uh, Punitive damages refer to the kind of damages that a court would issue in order to punish somebody. So they're not necessarily saying, hey, you know what, you suffered as a result, let me compensate you. They're arguing that, look, they lied and you should punish and make an example out of them for lying. We'll see how that claim goes. It's in my book, a little bit sketchy here, at least the way it's couched. The fourth cause of action is negligent misrepresentation. So, whereas in fraudulent misrepresentation, you have a scenario in which an actor deliberately misled someone in order to get you to achieve something, well, negligent misrepresentation doesn't necessarily require you to have deliberately lied to someone. It could just be that, well, look, you made representations and you didn't really know whether you could deliver, or you made representations and you dropped the ball in a way, right? You dropped the ball. You were neglectful, as a result, there were some kind of damages or damages of some nature should apply. And so here, Top Rank knew they couldn't deliver on the Spence fight. Well, hang on here. Let's see here. Yeah, let's see. Yeah, so here the argument is that Top Rank should have known that they couldn't deliver on the Spence fight, yet they promised it anyway. Mm, Here, this claim is a little bit sketchy in my opinion as well, because I'm not sure how you'd show that Top Rank would know that they couldn't deliver on the Spence fight. Now, you could argue that there's been some historical challenges between Top Rank and PBC, Premier Boxing Champions, who Errol Spence is signed with and does his promotions. But then there's also a history that the two organizations have worked together. So maybe through discovery, you could obtain some information or emails between the various parties that might show that they knew that there was a connection between, that not connection, right? But that there's some truth to this idea that they should have known that they couldn't deliver on that fight. I would say the same thing applies to fraudulent misrepresentation. Yeah, if you got an email between this guy DeBuff, who's Arum's son-in-law, and Arum himself saying, "Hey, listen, we're gonna lie to Crawford and say blah blah blah." Well, or like, listen, let's just say what we gotta say to get them to agree to the Mean Machine fight. If you can get them, you can get an email, uh, or some type of internal memo showing that, then you just hit the jackpot. But I can tell you that these guys aren't the type of guys that are silly enough to put that type of stuff in writing. No, these are conversations that they have when they're on the yacht somewhere at home. So, yeah, good luck with that claim. You know, it's certainly possible for more facts to emerge that'll make it more foreseeable, more believable that there is fraudulent or negligent misrepresentation. But I'm not entirely sure what those facts are. Just that obviously they could exist and that would change things. But that's the nature of that claim. Beyond that, you have your breach of implied covenant of good faith and fair dealing. And in general, when you sign a contract with someone, there's always an implied covenant of good faith and fair dealing. And basically, what that means is if you and I enter into a contract together, there's an expectation that you're going to act honestly and fairly and, sort of, not screw me over, right? Now, we often think of the law as something that's excessively, technical. But at the end of the day, it's impossible for you to account for every single potential problem that could occur in a contract. So let's say if you're forbidding the other party from doing X, Y, Z, no matter how, if you truly made a list of things that the other party couldn't do in a contract, the contract would be 10,000 pages long, right? So what we do then is that we combine equitable principles into legal principles. Back in the day, courts were, there was courts of law, and then there are courts of equity. Well, now, in particular in contract law, we see both of those combined. So there's this sort of requirement for people to be good to each other when they're in contracts. And what Crawford is alleging is that essentially Top Rank was not. What does he use? Well, he used things, for example, that Top Rank said, right? That Arum said, right? On behalf of Top Rank. For example, Arum made, here he is in paragraph 11 saying, Arum made the Arum statements about Crawford because he was upset that Crawford was likely not going to sign another promotional agreement at Top Rank. And with those statements they're referring to, they're elsewhere herein, right? He's talking about statements that he made along the lines of, hey, yeah, I've lost, he famously made this claim that he lost so much money on Crawford he could build a house in Beverly Hills, an expensive one, a nice one at that, or whatever, right? Now, so this this is a very strong claim in my opinion, because here's the problem. At the time he made those statements, at the time he kind of went on that smear campaign, uh, Crawford was still, they were still in business together. Contract was still binding. He was still his promoter. You can't trash your fighter as a promoter. You can't trash your fighter. right? Because you would very clearly would be violating this implied covenant of good faith and fair dealing, if not violating other more explicit provisions in a contract. Now this is a business strategy, though, right? And what it is that if you have a business and your business has an asset, in this case, Crawford is essentially an asset, right, to Top Rank. And so your business has an asset. If you're in danger of losing that asset, they look at it like it's a zero-sum gain, meaning whatever they lose, their competitor is going to gain, right? So what they want to do is then trash the asset and devalue the asset so that if the competitor obtains it, then that asset is worth less. So that's one approach. The other approach is this idea that obviously by trashing the asset or trashing Crawford, it's going to be more difficult for Crawford to obtain a lucrative deal with a competitor. Therefore, Crawford then is forced to come back to the table. This is a reality of business. It's nasty, but it is what it is. But I would say that this is a rather strong claim here because it's very difficult for Arum to justify the kinds of remarks that he made against his own fighter. This also makes Crawford's claims about racial bias seem more credible. Why? Because I think we can agree that Arum has never said this kind of remark about a non-black fighter that I can think of, and he probably would be unlikely to do so ever. So there's while there's the business considerations, there's also this idea that in business, people are often treated differently based on how they're perceived and based on perception. So there's not much legal consequence to this sort of racial bias language and the manner in which this lawsuit was couched, but you could argue maybe it provides some indication of why Arum operated in the way that he did. In general, though, the references to race throughout this lawsuit probably have more to do with wanting to attract attention to it. It could even be malicious in terms of Crawford wanting to make sure that, look, the same way Arum, impacted my brand and impacted me, well, okay, I'm going to lash back now and impact the Arum and impact the Top Rank brand. Is obviously the very likelihood that what he's saying is true. That's always possible. Arum could be an avowed racist or non-avowed racist, you know. But as I stated earlier, though, he's undoubtedly going to use in his defense the fact that the guy went into business, and if I'm not mistaken, Arum is Jewish at that. He went into business with the Nation of Islam. So, with several members of the Nation of Islam. Now, I don't find that surprising because I recognize that, at the end of the day, money, what is it? Money talks and BS walks. But if you're outside of this looking in, it's going to be an uphill battle to convince someone Arum is racist when you look at who he's done business with. Even though I personally don't find that to be compelling, I certainly believe a judge might. Outside of that breach of implied covenant of good faith and fair dealing, there's basically a tortious breach of implied covenant of good faith and fair dealing as well. And I would say that these claims are basically the same. It's just that the second one is couched as a tort. So when we talk about a tort you could look at it as more so a civil or even maybe a societal wrong, right? Versus breach, plain old breach is just a contractual wrong. Those things are treated very differently. Like, for example, oftentimes people don't realize that breach of contract a lot of times boils down to money. In our legal system, we believe that people should be able to breach contracts for the most part whenever they want to. And that's why it's important to assign a value to contracts or a value to contractual provisions and terms so that if you breach, you have a way of compensating someone. Because imagine this, if you couldn't breach a contract, that would infringe on one's freedom in a major way, right? And so explicitly, for example, contracts dealing with personal services those are, you can always breach those, right? So if I enter into a contract, for example, to be your butler, and I say the contract is going to last for 10 years, you can never, ever, ever hold me to that 10-year period because, sort of from a public policy perspective, it would almost equate to like slavery. It's like I don't want to be your butler anymore, but I don't have a choice to be because of a contract we signed 7 years ago, right? So the law allows you to breach that contract. But again, you might find provisions in a contract that'll place a value on it, right? Or that deals with what might happen in the event of termination, right? So if I terminate this contract with you and I leave as your butler in the seventh year, what do I have to do? Well, it might say I might be responsible for the cost of replacing my services with a new butler. And even then, right, it wouldn't be the whole cost. It would be if it cost extra, then I might be responsible for the difference between the two. Anyway, far too much in that direction. But the bottom line is that they make both of these claims. So you have the sort of breach from the contractual perspective solely, and then you have this tortious breach, which would also open the door to perhaps additional and certainly different kinds of damages, because the manner in which they breached and the impact that it had. So for example, there's one thing to breach the implied covenant of good faith and fair dealing for a legitimate reason. There's another reason. I mean, it's a whole nother thing to breach it because you deliberately want to cause harm. So that's where that tortious angle comes in at as well. Prayers for relief. What they're asking for, what Crawford is asking for here, he wants top rank. He wants the court to find that top rank breached its contractual duties. That opens the door to all these damages. Under B, we have their monetary damages. We've got punitive damages at C, which is basically punishing. Now D, we have awarding interest in the amount according to proof. So let's say if the court finds that, look, top rank should be on the hook for $5.5 million, let's say, then, okay, based on when Crawford would have been owed that 5.5 million, Crawford is going to argue that interest should be applied retroactively. Sometimes that can happen. Sometimes interest is applied post-judgment when there's issues of collection. But either way, though, if he prevails in this suit, there probably will be interest. That would be granted. And then lastly, attorneys' fees, cost, and special damages, and they're citing a case here. So anyway, that's what we have. That's the case. I think it's a decent lawsuit in terms of his ability to prevail. I think some of these claims are certainly stronger than others. The breach of contract on the Kavalauskas deal, where he says the 900,000, the bonus in excess of 900,000. If they made that claim, if it's in writing, or even if it was not in writing, if it was verbal, but if Crawford can prove it, then I think that's going to be somewhat of a slam dunk that he's going to end up being issued a bonus in excess of 900,000. On the breach of contract with respect to the Spence fight, I think it boils down to a problem of damages. I really see that boiling down to a profit. And I'm sorry, I misspoke there. The Kavalauskas breach is a slam dunk. The promotional rights breach of contract, where they were supposed to offer the two fights between 2019 and 2020, in my opinion, that's also a slam dunk. So that's 4.5 million for that. There's over 900,000 on that Kavalauskas deal. I think both of those are slam dunks. I think the fraudulent misrepresentation claim involving the Spence fight is problematic because of a lack of damages. That's what I believe. And I'm not sure that a court would be persuaded to issue punitive damages because they made that claim, because I think it's almost impossible to prove that they deliberately lied, and I think it's relatively difficult for them to prove, for Crawford's team to prove, that they knew they couldn't deliver on the Spence fight. It's just not. And the thing is that because everyone knows that you can't force, for example, PBC or Spence to take the fight, a question arises of whether or not Crawford even believed it. And that kind of takes us back to the bonus of 900,000 plus. That's the purpose of that bonus. That if they don't deliver, you get the 900K plus, which Crawford will likely get in this scenario. But these fraudulent misrepresentation claims, in my opinion, are not particularly strong. The breach, and lastly, for those breach cases, for the breach claims, I think the breach claims are strong because it wasn't just, I mentioned just the one main comment. It's listed elsewhere here, but there's several comments that he made, and I think it's extremely difficult to explain why Arum would have made those statements. I think he's going to have a tough time. The fact he is so advanced in age might offer a potential defense. Arum's team, Top Rank's team may say, look, Arum at this age is, he just turned 90. Yeah, he speaks his mind. So however old he was when these statements were made, 89, 88, or what have you, he's a pretty old guy. We know old people, tend to kind of speak their mind. Um, that might not necessarily offer him a lot of protection, though, because at the end of the day, if those statements damaged Crawford, then Arum's got a problem. Then Top Rank's got a problem. And I would say here it's probably clear that it has. I mean, the word on the street just continues to be that Crawford he's not able to really deliver, from a business perspective. When I say deliver, I'm saying that he's a marked asset. He's soiled goods. This idea that, man, the guy is so good. He's a great fighter, but he doesn't sell pay-per-views, and I have issues with that. First of all, it's the promoter's job to promote. Secondly, the pay-per-view is not the only relevant business model in boxing. Thirdly, which is something that people don't talk about, when you have a guy like Crawford in your stable, it's not only a matter of how much pay-per-view sales Crawford generates. You know what else is about? Your ability to recruit and sign other high-profile fighters. For an example, anyone who thinks that Top Rank's ability to sign Shakur Stevenson was not impacted by the fact that Crawford was also on the Top Rank stable is extremely naive. Well, how do you quantify that? Was it Keyshawn Davis, if I'm not mistaken? Up-and-comer, great, extremely talented. I'm pretty sure he's with Top Rank, excuse me if he's not. But yeah, but the bottom line is that, yeah, when you have a guy like Crawford, it legitimizes your company. It shows the world you're still relevant, and it helps you recruit additional talent. So that needs to be accounted for as well. So that's just in my little defense of Crawford's value to Top Rank. But either way, yeah, this lawsuit is likely a bag of mixed goods, like most lawsuits. If you think about it this way, if you think you can prove 5 claims when you file a lawsuit, yes, as attorneys, you have ethical obligations that would suggest that you should limit your lawsuit to those 5 claims. But on the other hand, you have an obligation to zealously advocate for your clients. You get, to an extent, one bite at the apple. So therefore, if you're going to come at someone, you're not, as an attorney, you tend not to come at them with just the 5 claims. You're going to come at them with 10 claims, right? You're going to come at them with anything and everything you can think of, and prevail on the ones in which you can prevail, and the ones that don't, they fall by the wayside. But in this case, I would say this: it is impossible. It is impossible, based on what I read, in my opinion, for Crawford not to be partially successful in this case. So it's a no-brainer that what he did here was a great idea. I think it's a great way, not just financially, not just what he can accomplish financially, which again, I would argue it's a certainty he's going to be awarded X millions of dollars, but also in terms of his legacy. There are many people who legitimately don't know whether or not Crawford really wanted the Spence fight. So when you look at a lawsuit like this and it gives you a little bit of a glimpse into the inner workings, and you're able to find out that, oh wow, Crawford really did want this fight and he was getting played. Now laymen will say, well look, if Bob Arum was this bad, well why did Crawford resign? And I can't emphasize this enough. That's not how business works though. With business, you want to attack business a lot of times and in a lot of different sort of situations, not really with emotions, but with the bottom line. So if Crawford, let's say Crawford knows Arum let's say Crawford believes Arum to be a racist. That is not in and of itself, from a business perspective, enough of a reason not to re-sign with them. Now, is it enough for very many people? Absolutely. Would I sign with a racist? Absolutely not. However, the best decisions in business have more to do with the bottom line than anything else. And that's true for very many people. So at the end of the day, he's getting about 4.5 million for a fight, 6 million for that last Porter fight, and if you want to be cynical, you can say that he was going up against people that had a very small chance of beating him, and 2 fights a year. So the guy's making $9 million a year on average to fight people that he's almost certainly going to win against. That's not a bad deal. Like, let's be real. That's not a bad deal. Now, of course, as anyone gets older, much less someone as talented and great as Crawford, as you get older, you become more concerned with your legacy, with what kind of legacy you're leaving behind. In particular with Crawford, given his amount of talent, in my opinion, Crawford is an all-time great in boxing, and arguably we've been robbed from seeing that. In my opinion, he's got a couple years to accomplish some extraordinary things, and I still think he can do it. If he knocks out some of the biggest names in his division, moves up. Let's just imagine, he takes out Keith Thurman. Let's imagine that he takes out the winner of Spence and Ugas, who people assume is going to be Spence. I'm not so sure, but let's imagine he takes that out and he becomes undisputed at 147, right? And then and then let's imagine he goes up to 154 and takes out the winner of Charlo and Castano. It is possible for Crawford to become undisputed. Earlier, I think I mentioned undisputed at 130 or 135. I was losing it. No, he was undisputed at 140 previously, right? At light welterweight. Now, let's imagine Crawford becomes undisputed at 140, at 147, and at 154. Crawford would make history. I'm not sure that that would ever be achieved by any other boxer ever. Certainly not in this four belt environment. So Crawford can still cement his legacy. It's definitely possible. I don't think I think this lawsuit will help at the end of the day. People tend to be discouraged from dealing with people who have who are litigious, and I'm really referencing something that I heard someone else say, and I would agree with that generally. But these people aren't fools; they know what the deal is. So the fact that a party sues someone doesn't mean that you're particularly litigious. It just means that you're willing to sue if you feel you have to. And I think everyone agrees that in this case, Crawford is justified in doing so. So, bottom line, it's a strong suit on the breach of contract claims, not so strong on the misrepresentation claims, and it's reasonably strong on the breach of the implied covenant of good faith and fair dealing. Any questions at all dealing with this, feel free to put it in the contents in the comment section below. Like, subscribe, share. I'm going to grow this channel. You can also shoot me an email at help@iilawfirm.com if you have any questions, just from an educational standpoint, or perhaps if you need legal counsel. I operate in the state of Colorado with respect to typical state law issues, but lawyers can sometimes go into other states and represent clients based on the circumstances, and if they comply with the Supreme Court rules. That's what happened in this case, where Crawford is being represented by Friedman under Nevada's Supreme Court rule. I believe it's 47. Friedman is not licensed to practice in Nevada, but process is generally called pro hac vici. It's Latin term. Anyway, thank you guys for listening. If you have any questions, feel free to reach out.